can.
Hi, it's Catherine. Let's see. I hope you guys can hear me.
We can. We were waiting on you.
We can hear you.
Okay. Do we have everybody on?
We have a quorum. We're just waiting on you to get started
Okay.
to call a meeting to order.
All right. Hold on, guys. Let me pull my stuff up. Okay, I thought I had this all prepared. Hold on. Sorry, guys. I just got here. And okay. I guess I tried to log on to my board effects too many times and it kicked me off. Is there a way to clear that?
Yeah, we'll, for the interest of time, we'll go ahead and send you the link to the packet right now.
Are you sending it on the Outlook?
You want me to send it right here on chat?
I'm sorry, what was that?
Right here on the chat room?
Oh, okay.
Or if you like, I can also project my screen.
Let me find it. Okay. Alrighty. Oh, where'd it go? There it is. Okay. Okay, can we call the bylaws committee meeting? And can we begin with roll call?
Yes. Catherine Robles,
Present.
Carl Sergio,
I'm sorry. Did you say my name? Present.
Carl Sergio.
Present.
We have Oliver Bain. Jamie Rogers.
Present.
Linda Hayes.
Present.
Have a quorum.
Okay. Next, we need to get a motion for approval of our minutes from November 9th, 2020.
So moved.
Linda. Oh, I second it.
Okay. Now we're just going over some information on number 4 in regards to our 2021 expiring terms. On page 5.
I think we have to take roll call for the approval.
Yeah, I didn't hear a vote.
Oh, we have to do a roll call. Okay, so can I?
So, Robles,
Yes.
Carl Davidian,
Yes.
Jamie Rogers,
Yes.
and Linda Hayes.
Yes.
Okay,
And Ken, we don't have to open it to the public because there's no public.
Well, I mean, you're still supposed to technically do it, but if there's no public to open it to, I don't see anything.
The staff are considered as public, Ken?
I'm sorry?
Do staff count as public?
They do, absolutely. Special kind of public, but yeah.
So Catherine, you need to say, are there any public comments?
It's best to do it after the second, but before the roll call take.
okay, so we want to push up number 8, public comments to,
No.
This is
Go ahead, Ken.
for each action item. What we do is before we get our roll call, we just ask if any member of the public would like to speak on that item.
okay,
And we do that in addition to the public comments that are on the agenda, the standing public comments.
okay. After each item.
Correct. So once you get a motion in a second, then
Okay.
you say, is there any public comment? There being none, and then you just ask for roll call.
Okay, alrighty, so on number 3, approval of the minutes, I received a first and a second. Are there any, before we do roll call, are there any public comments?
And then you say hearing none, and then you ask for the roll call vote. Just like I do when I run the board meeting.
Okay, hearing none, let me have roll call.
Okay, we take roll call again. We have Pastor Robles,
Yes,
Charles Davidian,
Yes.
Jamie Rogers,
Yes.
and Linda Hayes.
Yes.
okay, so now we will move on to number 4, which is informational, 2021 expiring terms.
Yes, this item before you is an information item only to keep the committee members appraised of the upcoming expiring terms of commissioners for this year. So the commissioners will be notified different forms of their upcoming expiring term, 90, 60, and 30 days reminders prior to their application being submitted. And we have them outlined in the staff report for your review. It's an informational item to notify you of the commissioner's expiring term for this year.
Okay. Well, I appreciate that, and I'm glad it's finally on paper that that notice reminders will be sent out. Since this is informational, we don't have to get a motion on this, but do I still ask for public comments?
Yes.
Okay. Okay, so any public comments? Hearing none, I believe we can move on to number 6, which is our bylaws revisions.
Number
No,
5.
sorry. Number 5, election materials,
Yes.
which is on page 6.
Yes, so item number 5 is staff recommends committee review and approval for full board consideration of the election materials for 2021. On here, you have a number of documents, which include a timeline of the 2021 dates, community sector public notice, community sector representative forms, target area public notice, and target area vote registration form. All of these items have been updated with the new dates and will be posted on the Fresno EOC website. We'd like to note that the registration and voter forms, we will, our hope is to have them entered electronically on our website so that people could submit that online as well as like people, but also providing another platform.
Okay. Did Karina, as far as this past election period, did we run into any hurdles did the process more or less, other than, one application coming in past the due date, but on your end, was it smooth?
It was. I did adjust the timeline a tiny bit so that the the bylaws committee is able to provide so that it's able to review and interview the applicants and make a recommendation in time for our next board meeting or December board meeting. And same thing with the public sector, the community sector applicants as well. So I think I adjusted the timeline so that everything's pretty much in time, in preparation for December board meeting, and so we're not running into that little issue.
Okay, and then with the community sector on, it's stated now that it'll all be virtual interviews.
Yeah, let me double check. I put virtual links will be provided for the ballots. Screening committee interviews, community sector candidates. We didn't specify that they're virtual, but we can go ahead and add that virtual wording on there as well. And we were proposing a similar timeline of a Monday and Tuesday of November 29th and 30th.
Okay. Any questions
would
for
you-
the
would you-
committee members?
I do. I mean, I wouldn't put it, I would say, if we are not back in, if our city is open back up, then I think we need to, if we put virtual and the city is back open and some people we want to do face-to-face and go back to what we used to do, or are we stating that we are changing how we do this process and we will only start doing our screening and interviews virtually?
Well, that's a good question for the rest of the committee. I mean, how do you guys feel in regards to doing interviews via Zoom or in person?
I think they should be in person. If we're
Me
open
too.
back up.
If the city is open back up, I think we need to go back to
in
face
person
to face.
interviews. Yeah,
Do we want to offer that as an option?
no,
no.
Okay.
no. Because we've stated before, several years ago, you had to make that date, you had to be there for the interview. So now we're changing it. If we do half there and half virtual. No, if the city is open, we should be doing regular interviews.
Okay.
And I don't think we need to change anything on the form. I mean, it's going to be just like we did this year due to the COVID pandemic. Everybody know that it was virtual. But if the city is open back up, then we will be doing things face to face. Now, the opening of the ballots, I can still see that being a virtual link provided for public view, like we did last time. I wouldn't change that.
Okay.
I would leave that. But everything else, I would just leave it the way it is.
I just think when you're counting the ballots, it was, it was the first time with that type of experience, but it was kind of hard to hear you guys communicating. So I don't know how important having audio is, or is it just a visual watching you count?
It's a visual. We are not communicating with the auditors. They're doing their process. It's not a lot of dialogue that's going back and forth, and there shouldn't be.
Okay.
Only people be communicating is the auditors communicating with the people that's counting, and then Amelia is taking the final vote so she can report out. But it's not something that you need to be having a dialogue going back and forth.
Not necessarily a dialogue. It's just, it was a little bit hard to hear just where you were at with each targeted area. So maybe if you could put something in writing up, I don't know, it's just kind of hard to follow.
Yeah, we could, what I could do on our end is that we could do a run through internally to make sure that the audio and visual, it's okay, and everything looks transparent to the public. So,
I think what she's saying, Karina, is that the audio visual was not an issue. I think what we can do before they start the count, we can announce every step. So right before they start the count, whoever will designate one person, it could be Amelia or whoever the chair, say, okay, we're getting ready to start the count. And they're starting with target area A. And then each step of the way, just announce what's going on. So those who are watching will know what the process is. Is that correct, Catherine?
Absolutely.
Okay. I think our equipment was fine. I think
Yeah.
they just didn't know what was going on inside the room. So if we could just announce each process, each step along the way, I think that will satisfy what Catherine's talking about.
okay.
And actually just maybe a little orientation as to the process, because you guys do count the ballots twice, right?
Yes.
Yeah.
Well, maybe Karina, you could work with whoever the person will be that's in charge of the counting of the ballots,
Yes,
maybe to give an introduction.
it's our internal audit, so I'll work with them.
Right.
Sure that
Yeah.
we,
So I was going to say Susan, but whoever that person is, just to give an introduction. This is what we're going to be doing. These are the ground rules. At each time, we will announce ABC and then start. And then maybe introduce the external auditor that's in the room that's overseeing the
Mhm.
process.
Okay, any other comments from committee members?
I have one, though it shouldn't be on the chronological order. Just an idea of maybe a courtesy call or email to the community sector reps, incumbents. You know, this past two cycles, I mean, Leroy was late, Pastor was late this year. It doesn't hurt to give them a call or text or email a week prior to the October 1st deadline. So, you know, this way we can't say we didn't, you know, let them know. I mean, it's hard to not to bend the rules of saying, okay, we'll still accept it after the deadline when they pretty much know the rules. But I just figure the courtesy call doesn't hurt.
Commissioner Garbino, you read our mind. Go ahead, Karina.
Yeah, I think we learned from last year and previous years to remind them, to go above and beyond and reminding them. And so we'll do a 90, 60, and 30-day reminder before the applications are due. We'll use the forms by email, mail, if we have to, phone call, and text, just to verify that, you know, they are aware and that there's no confusion from their expiring date and their application due date, which I believe is the confusion last year.
Okay, I have a question for you. On the order, when will the applications become available? Because that's not on the timeline, or am I missing it? No,
I
I'm
think
not.
that's going to be posted on the website. Applications, meaning our nomination forms?
Okay, so, yeah, the nomination forms, are you telling me that it'll be available on the website next month?
Yes,
Or
yes.
October?
Yes, we already updated them. They're in
Okay.
your packs as well, but we'll also make things a bit more like this. For example, this community,
7 months out. Okay, all right.
Yeah. which,
Okay.
for example, this community sector representative form, I would like it so that they can go on their website and just pretty much type in all this information online, and I can export it on our end. That we could also have it available like this on PDF for them to submit.
Thank you, Karina. Any other
you.
question?
Mm.
All right, can I get an approval, a motion for approval?
So
Jenny, I
moved.
need to approve.
For a second, I'll second.
All right, any public comment? With there being none, can I get a roll call?
Catherine Robles,
Yes.
Charles Garbidian,
Yes.
Jamie Rogers,
Yes.
and Linda Hayes.
Yes.
Thank you.
Okay, now we're going to move on to number 6, which are the bylaws revisions. This is up for an approval on page 16. Is Ken going to go over this?
Yeah, I think it might be a good idea. I have some thoughts and I have some comments in the red line, but
Okay.
if it's okay, I'd like to take it from
Well,
there.
before you start, I have to apologize because I didn't get this till late last night. And I was very busy today and I didn't get to go through these revisions. I don't know if the rest of the group has been able to go through it. And it seems like, oh, there's a few changes.
Yeah, and I thought what I would do, and that's a really good point. And my apologies too. I didn't realize the meeting was set for today until I talked to Karina last week. But what I'd like to do is to go through the red lines with you, to touch bases about them, give you my rationale behind them, and then I'd like to get as much input as I can. And I think it might make sense to recirculate this before it goes to the board, because I do think that, you know, the changes to the bylaws probably need a little bit of time and a little bit of percolation by the bylaws committee. But I'm not sure how. I would defer to you and to Chair Hayes in terms of the timing. If you feel it's better, it goes to the February meeting or the March meeting. It's really your call.
I would recommend going to the March meeting just because you have some bylaw members that's not on this, that are not here today, to give them an opportunity also after we go through it today to look at it.
And I think these meetings meet quarterly, right? So I would strongly suggest a special committee meeting, you know, maybe in as soon as a week or two after this, after I integrate your changes based on the comments I hear, and then we could discuss and finalize it for board of consideration. Does that seem okay?
I'm okay with that. Do we need to make a motion to
Yeah.
extend this to the
I
March?
could move to table it to our special meeting.
So Commissioner Robles and Garbini, we were asking, I think Ken was asking if we can go through it together right now.
Yeah.
So we can go
Correct.
over some of the revisions and get your feedback. And
Yeah, I'll walk you through it. I don't, it shouldn't take too long, but I'd like you to stop me, anybody stop me as we go forward and tell me if there's something that I've missed. I looked at it more for things that lawyers look at, you know, in large part the Brown Act compliance and you know, clarity, things like that. And I also identified a couple issues I wanted to raise to you. But if, like I said, as we go through it, please stop me and say, you know, stop, I have a question about this, or I have a suggestion about that. Because I think, you know, this should be a very interactive exercise, if that's okay. One thing I just wanted to point out as we start is Karina was nice enough to send me the articles of incorporation. It's in your packet. I put this up like this so you can see that this document was from 1965. And one obvious thing I note is that the name on the articles of incorporation is the Fresno County Economic Opportunities Commission. And in the bylaws, it's just listed as the Fresno Economic Opportunities Commission. So the name
Here is Fresno County, and then when Brian came on board, he said we do more. He decided to take the county off, the word county.
Right.
And that's totally fine, but you know, your articles of incorporation are your official registration with the state. And so if the name is changed in the bylaws, then we got to make sure that the articles are revised. And since this has been around since August 31st, 1965, it's probably a good time for a revision, I would think. So
and we don't have any updated articles. That's the latest one that.
Not that we could find.
Okay.
I went back a couple years to see what was included in the commissioner's handbook and what was provided to you guys. And I could only find a retyped version, but comparing them side by side, they were the same one for 1965.
We found other things that were filed, like what are called statement of informations and other things like Amelia sent and her and she's the agent for service of process. These are all things with the California Secretary of State, but we couldn't find any amended articles.
Okay,
So in our bylaws, we can, I see you've corrected it to the Fresno County Economic Opportunity Commissions. Can we also known as Fresno EOC?
Sure. Or, you know, the other option is that in addition to the bylaws, we bring back to the board some new articles. And if you desire that the name of the agency be Fresno Economic Opportunities Commission and without the county part, that's entirely reasonable. And we can modify the articles to reflect the new name.
I
But
think that should be a board discussion, a board decision.
absolutely. And I don't think the articles can be adopted by just this committee anyways. It would have to go to the board. Do you have a preference?
Well, I think the reason they got rid of county, well, the reason they removed the word county was they wanted to embrace all of Fresno, both city and rural areas. So,
And
it
wasn't
was-
there some confusion about being associated with the county of Fresno?
Correct. That was
Yeah.
also,
And
That
that
was
happened to
convenient.
us.
Between the two.
And that happened to us on our retreat. Somebody wrote a letter to the editor when we were at our retreat regarding Fresno County having their retreat in Monterey. And that is confused with the county of Fresno.
So the contracts that I review for you, it's always Fresno County Economic Opportunities Commission. But I have to tell you, if there's a desire to keep county because that's our legal name, then the bylaws have to have the legal name, not the informal name. But we could do a DBA, as you point out, Madam Chair. I mean, that's certainly something we can do. But we gotta make sure it's consistent and that we have it ironed out.
I think it's something that we should, that's a discussion for the whole board. I get what you're saying. But I don't think this board should make that final decision.
Yeah, no, I totally agree. And just keep in mind that both the bylaws and the art, if you do revise the articles, which I recommend, that would have to go to the entire board.
So let me ask you this, Ken, if we do revise the articles and change the bylaws, does it have an effect on all of the contracts that we have?
No,
Okay,
it's only to the extent that future contracts would incorporate the proper legal name.
got it.
But right
Okay.
now, when I see bylaws like this, like if we were working on a transaction and the opposing party said, well, I need to see your bylaws because that happens. And sometimes when you're doing due diligence, this
Mhm.
would immediately throw them off. They'd say, wait a minute, we have your legal name under your bylaws as being the Fresno Economic Opportunities Commission. Like that would normally happen like when you're buying property or things like that. So I think for whatever we do, we want to make sure it's consistent and right.
Okay,
Okay.
Ken, have you checked with the Secretary of State? Because Linda, I believe after the last retreat we did, wherever it was, with Brian, he was going to change the articles and officially change the name.
Yeah, that's where I got it from, is the California Secretary of State. In fact,
Okay,
I'm
so
pulling
it never
up-
happened. I just
Put it up
curious.
right now. Let me just double check here. I'm going to
And,
verify. that.
insurance purposes, contracts, all our documents say Fresno County Economic Opportunities Commission. That is our legal name. It's never been changed.
Okay, so if that's the case, then the bylaws should reflect that then.
right.
That's a no-brainer right there. It's
And I am
the
looking,
Fresno County Economic Opportunity Commission.
right now at your entity detail. The way you were registered with the California Secretary of State, you are registered as Fresno County Economic Opportunities Commission.
Okay.
And the latest statement of information, which was filed on 4/2/20, so last year, it's coming up, Amelia, it's coming up. We have to do it annually. It is, you are listed as Fresno County Economic Opportunity Commission. So, you know,
So our bylaws need to reflect that.
your bylaws don't use the correct name.
That's not,
So it's definitely something we want to, I don't have a preference. I just want to make sure we get it right.
Mhm.
well, right now, wouldn't you say that it needs to say Fresno County until we decide if we want to change it?
Yes, but
Okay.
what I can do though, Jimmy, is it takes like 3 days to get the articles recorded. So my advice to you is, since we're going to revise the bylaws anyways, it can go either direction. It's really not a big deal. As long as your legal contracts are correct, and they are, and you own title under Fresno County Economic Opportunities Commission, it's really no problem either way.
Okay.
Well, from that perspective, it just requires us to do more paperwork with our insurance and our carriers and our contracts in the future.
By
Right?
changing the name.
If we change it to Fresno Economic Opportunities Commission.
Right.
It's less work for staff if you just update the bylaws, because everything else is correct.
And just because the bylaws might say Fresno County Economic Opportunities Commission, it doesn't mean that for your branding and that kind of stuff, it can't just be Fresno EOC or whatever you choose it to be.
Okay.
So we keep going, and one thing that's a little bit unusual is under purposes. I put in red line there, it says let's discuss purposes and articles, because the way it's supposed to be done is that the purposes that are in your articles of incorporation right here, those actually should be directly articulated in your bylaws verbatim, and they're not. So I put that in as a placeholder for your consideration, but I really would like to reconstruct the purposes section to make sure that the purposes are not different from the articles, and right now they are, and that is not from a legal standpoint not a really good place to be in. That's why I think the articles need to be updated. So we keep going. One thing I noted also is that your articles of incorporation as specify that the board is anywhere between 25 and 50. And it says, provided that said minimum and maximum number may be changed by the bylaws duly adopted by the members. Well, this does that. But again, I'm not very comfortable with the idea of knowing that the bylaws actually specify 25 and you have at this point 24 commissioners. So I think that's another reason why you want to get your articles up to speed. So that's why I wrote that note inconsistent.
Okay, so you're saying that the articles are stating 24 to 50?
25 to 50.
25 to 50. Never heard that. Okay.
Let's keep scrolling down if you would. A lot of it is just little things. Sometimes I note to myself, like that in order to meet the Head Start requirements, the board requirements, I just like having the citations. And so can you put that back up on the screen?
Yeah, give me 1 second. It will show you link for a second.
And we'll go to Article 6 under terms of office when you get back up.
I hear a lot of echoing in the back. Are you guys?
That's better.
Okay. Sorry.
So why don't, if you could keep scrolling down just a little longer. Okay. Under Article 6, what I noticed is that there was some vague language in the section, and I would like a little bit of clarity as to what it means. At the bottom sentence of Article 6, it says an individual designated by a community sector organization to serve as a community sector commissioner shall so serve only while he or she continues to be associated with the organization that designated the commissioner. Now, I don't understand what that means, because if you look under Section 2, if you look a couple pages down under vacancies, which is Article 7, it says that community sector commissioners, when a vacancy occurs in a seat held by an individual designated by a community sector organization, the board shall ask the community sector organization that designated that individual to designate another individual subject to approval by the board to fill the vacancy. And then it says, should the community sector fail within the period of time specified by the board to designate the individual, the board shall select another private sector organization to designate the individual subject to the board approval. But there's another section too that refers to, where was it? It referred to association. Well, it suggested that there was an employment relationship.
Is it section? I think it's Section 7, employment of commissioners. But to be honest, Ken, I actually like the word associated versus employed, because many of our community sector organizations are small. They don't have a lot of employees.
They 1099 folks,
Oh.
maybe, or they have volunteers.
Right. So they're board members, or like NAACP, I would bet Leroy isn't employed by, or Jimmy isn't employed by, but they're associated with. Or ITSE is a board member. Michael Reyna was a board member. So employed is probably too strict, but up to you guys.
No, I appreciate that. There was some other language, and I'm trying to find it, that suggested it should be more than just an association, though. I have to find that language. Maybe I'm just missing it, but I would prefer that the word be defined. It doesn't have to say employed to me, but the word association is a little bit loose.
So more like just the person representing, the
Yeah,
representative of the organization.
correct. That seems like a reasonable word.
Yeah, because when you talk, you speak to that very first one, if I should leave that organization, then that would, I shouldn't be on the board anymore, because the organization nominated me to the board.
Yeah, shall so serve only while he or she continues to be associated with the organization.
Yeah.
So associated could mean volunteer. It could even.
Yeah.
And what if someone is removed from the organization, but they're still somehow associated? I mean, removed from the board, but somehow still associated with the organization. I just wish there was some, or maybe the other option is that the community sector organization adopts a resolution of appointment, like it has to be a board appointment. So irrespective of what status they have with the community sector organization, as long as there's an action to appoint them to our board, they're on our board.
But the purpose of them being appointed by that organization is that they are representing that organization on our board. And so
Right.
if they are not really, I mean, that goes to say that they could appoint their friends or someone who have a interest in EOC that's not at the best interest of the organization, and they can appoint that person to be on our board to make decisions that's in favor for them. And so I don't like that part, because it's too vague. It gives somebody people an opportunity to put people on our board that don't have the best interest of the agency. And then it can become very personal, and then they want to push their own agendas.
And
Well,
not necessarily the interests of the organization.
no,
Right.
and I
Well,
completely,
exactly.
I completely understand that. What I'm struggling with is, at what point are they no longer associated? So I think
So-
there just needs to be some clarity so we understand what that means.
Well, let me ask this question. Does each of those community sectors, they could either have to be on their board or employed by that agency?
Okay, now that helps. So if we took if we use that word and we kept associated, and then we put another sentence that says, associated for the purposes of this bylaw shall mean either A, serving on the board, or B, being employed, or C, maybe serving as a, I don't know, independent contractor rules are so weird now. But I mean, or you could say compensated consultant or something like that, I guess. If they don't employ somebody, if they use an independent consultant.
I want to stay away from that, because then, I mean, you could look at, they're compensating someone to buy their vote.
Yeah, because I'm an officer of my organization. I am not compensated in no way. And they do a proclamation to nominate me. If I should walk away from that organization, they no longer have a seat at the table. That's how
Unless
I feel.
unless they appoint someone else
Unless they appoint
in your
someone
place
else.
for the organization.
right.
Yes.
So if we have to specify that position, that person, we'd have to go back to our community sector representatives public notice, because on there, it just states that person as a representative. Community sector commissioners are representatives of business, industry, labor. Okay, so that's just the organization itself. But I mean, my question is, and I'm probably going off track here, is does an organization, are they given all this information should these issues arise where we do lose that representative? Like in Michael's case, did Real Pride, did they know what the process was?
Yes. They were given a handwritten letter, and then they were given 2 weeks to reply to that notification. And what we're doing, Catherine, if we're not even saying that, we're just reviewing this information.
No.
What?
You're right. No. That's why I said I'm probably going off track, but Real Pride, I mean, they got notice after the fact, but shouldn't they have some kind of instructions prior? When they're sitting down discussing whether they should have a representative on our board?
To
That's
me,
a
that's not.
Different
I
discussion.
don't. Pardon me?
Just
I
a
don't think
different
so.
discussion.
Well, if they're doing a proclamation or a resolution, they should know what they're proclaiming or giving a resolution for before even doing it, right?
Right.
Right.
Exactly.
Mhm.
Is
Well,
James
I
on
guess-
that board?
Yeah.
Yeah, but okay, I'm just thinking they have to understand exactly they have to understand the title of that person that's going to sit on our board. That's what we're trying to figure out now, right?
Well, that's why they have the proclamation, is because let's say
Right.
somebody wants to be on the EOC board and community sector rep, they go to a nonprofit organization, and nonprofit is going to say, okay, but I want to know more about Fresno EOC, and therefore they have to do that proclamation. So EOC has to give them that information so they know what the organization is about, so they can decide that, is this person is worthy of our proclamation to be a representative.
Okay.
And I think it's one thing that we should look at. So.
My only concern by raising this in the first place is that if there's an internal dispute by the community sector organization as to whether or not someone continues to be associated. When you don't have objective criteria of what that truly means, you might run into trouble as to whether or not that person truly represents the interest of the CSO. So that, but I really like the idea of maybe, and you know, and again, if you aren't comfortable with this, I understand, but I really like the idea of adding a sentence to the end of it to say, for the purposes of this section, quote unquote, associated shall mean either serving on the CSO's board of directors or being employed by the CSO. I'm just CSO meaning community sector organization. I like that because then it eliminates the risk that someone might say, well, I'm still associated with them, but I'm a volunteer, or I serve on a subcommittee, even though I'm not on the board. To me, that there's some value to that, but you know, maybe I'm creating a situation that doesn't or shouldn't exist. I don't know.
I like that. I like that.
So as staff, it would be beneficial for us to be clear, because then we have it for future, so we treat everybody the exact same way. And Ken, I was going to ask also for the public appointees to go over that section, because it says that the public official should appoint another public appointee. So what does that mean? They can pick their friend to be on the board?
Well, I actually thought that they meant another public official.
Yeah, that's what when I read that, that's what I see, but that's not what's being practiced.
Mhm.
So it says when a vacancy and I'm sorry, I'll move forward.
Sorry.
Oh, and by the way, just before we do move forward under Article 7B, every bylaw should have a jurisdiction for the organization, especially since we're public now, or we're sort of quasi-public. And so I just said, for the purposes of California law, the jurisdiction of the organization shall be Fresno County, but we can conduct business outside of Fresno County, which of course you do. I mean, you may do work in Madera or something like that. So now going forward to where I think you were talking about under the vacancy section, Amelia, under section 2A, under public sector commissioners.
Mm-hmm.
So I noticed that too, and I made a note, and it was more like, you know, if that's interpreted to be a public official, then that triggers mandatory Brown Act compliance anyways, because let's say you have a city official who serves and they appoint a council member, for example, that's automatically triggering Brown Act and all governmental stuff anyway. But what it says when a vacancy occurs in a public sector board seat held by the representative of the public official, so that would mean a non-public official, the board shall request that the public official either take the seat himself or herself, and this is what the situation you were referring to, or put forth another representative to be elected by the board. So the way I see that second part of the sentence is to mean it would not be a public official. The first part would mean that it would. So if it's a city, and they take action to designate a non-council member, and that person leaves, either a council member can serve, or the council would put forth another representative to be elected by the board, which would be the city, I guess.
So the city would have to appoint them. It couldn't be a simple letter from the mayor saying they're appointing this person, or a congressman, I appoint this person.
Well, it depends upon the sector. You know, what's weird is it says elected by the board. Does that mean elected by our board, or does our board have to take action to accept that person? I don't think so, right?
Our board has to ratify the appointment, yes.
Okay, so maybe when it says elected by the board, that's what it means. It's very unclear to me. Maybe it could say, or put forth another representative who, and it really should say either individual would be ratified by the Board of Commissioners.
Mhm.
Yeah. And so the only thing I want to be clear on, Ken, for the community sector and the public sector, that these appointees are relevant to the individual pointing them and is relevant to our vision and mission as an agency. So if we're going to be, and we want to be consistent. So is it an elected official in the public sector, or is it appointee in their area, in their sector? I just want to make sure that it's not who they want.
Okay, so if you go back to selection of commissioners, it doesn't have any qualifications under public sector commissioners that they have relevant experience. So if that's the desire, then you'd probably want to add some language to the bylaws that actually speak to relevant qualifications, if that's what you'd want to do. You could say for public sector commissioners, the public sector commissioners appointed shall have, at least one of the following experiences or something like that. So you have some qualification to the person. I don't know. It's really, that's your call as a board.
So Ken, if you can give us guidance, because it makes sense, like the mayor, the city of Fresno, that they elect a resident from the city of Fresno and not from Sanger or Madera. And like the two commissioners appointed for the Fresno County Board of Supervisors, it's within their county board of supervisor, or on their board related or work for them. But like the judge, is it, if it's not him, is he appointing somebody that works for him or somebody on his board, or just a community person that wants to be a part of it?
Well, that one is a little different than the rest because it says one commissioner appointed by the Fresno County Superior Court judge sitting in the juvenile department. But it doesn't mean that, I don't know what the word, what about a Fresno County presiding judge sitting? Amy, do you know what that means? Does that mean that the judge should be, it should be a juvenile? It's not clear if it's a juvenile department judge or an employee of the juvenile department. But because the Fresno County Superior Court presiding judge is the judge for all of the Superior Court, and it's unclear what the verbiage sitting in the juvenile department really means.
So there is a juvenile court has its own presiding judge. So there's one overall for the entire Fresno County Superior Court, and there is a presiding judge for juvenile court. It just changed. Oh, I thought Mary Dolas, I think, is the new presiding judge for juvenile court. That's really what that's saying.
Okay, so that just has to be clarified. So it should say the Fresno County Superior Court presiding judge for the juvenile department.
Yeah, there's if you look on the list of judges,
yeah,
on the Fresno County Superior Court website, you'll see there's a presiding judge for juvenile.
Okay, thank you very much. So to answer your question about that, you are relying on all of the public sector appointers that the person they're appointing has experience relevant to what you want.
Can we make sure that they're certifying that they live within their district and represents the mission and vision or something like that? Because that's what I see as a proclamation or resolution, because it's the board that proclaims that this person is representing us, aligns with our vision, our mission, our goals.
Yeah, that does not fit. That is not in there, and that is something you can certainly add. But what I'll need some assistance from you, Amelia, is coming up with the qualifications for that.
And I think there's somewhere in here because we want somebody with early childhood experience, and that we have that in there somewhere. I forgot exactly where.
No, you have that as it relates to specific seats under the community sector commissioners. It just says community sectors commissioners may consist of representatives of business, industry, labor, religion, religious, law enforcement, etc. It lists it all down. But those are not skill qualifications, and those provisions certainly don't apply to sub A.
So Ken, we do need someone, and then we need someone with early childhood, and then we need an attorney someone with that background also on our board. So does that need to be spelled out in our bylaws?
Yes, and I think there's a section in another area which mentions a
It's-
attorney.
It's right above the section we're talking about. It's section 2, Head Start Board composition requirements.
Mhm.
Go up a little bit higher.
Yeah.
Keep going. I think, where is it?
Yeah, I remember seeing it. It's
It's on page
19
19
maybe?
of it's up, Karina.
There it is. Keep going up a little
Yeah.
bit more.
It's on top of 19, right there.
There it is.
yeah, so that's saying it must include those features, and those are Head Start requirements. That's why I put the citation there.
Okay, thank you.
But that
Yeah.
is, again, that won't necessarily apply to the items, to the list that Amelia is talking about. Which, so, it doesn't speak to domicile, or it doesn't speak to the mission and goals of the agency.
Yeah, because for the target area and the community sector, both of them, each of those appointees have to kind of justify why they're going to be on our board. How they align with our vision and our mission and coincide, and especially being elected, they have to actually do actual campaign for their election. However, with the public sector, there is no parameters. So some elected officials are very good and state why they're selecting this person. And they verify, and Amy, I'm sorry to use you, but you're on here, but your son definitely said why you were relevant to being appointed on this commission.
But maybe that's providing a sample letter, just like we would provide a sample resolution for community sector reps, just so that they have a sense of what it is you're looking for. But most public officials are not going to want to be embarrassed by appointing somebody from Madeira to sit on, this on EOC to represent them, or if they're strong, you know what I mean? They tend to be pretty cautious for the most part.
Has this ever happened before? No,
I would have to ask any of you.
not that I can think of.
So when looking at the lead-in language before, under that Article 5, it does say, in fairness, it says that after each prospective commissioner has been selected to serve on the board through the appropriate selection process, and has been determined by the board to meet the qualifications set by the board from time to time for service as a commissioner. So I guess what it attempts to do, and I'm not sure how the sequence works, because it's not very clear to me, even from the policies that I've seen, is it does allow the board to, I guess, once the name is advanced, for the board to say, well, maybe through the ratification process, they do meet the qualifications that the board from time to time requests. So if that process is acceptable to you, we can do that. I think what Amelia is suggesting is maybe some kind of an affirmation or certification that the person has experience in the areas that the EOC is carrying its business in. Like you mentioned, it doesn't have to be early child care, but it can be early child care. So I defer to you in terms of how you want to handle that. If you want to keep it as is, or if you want to create some kind of a process there, we can do that.
I'd like to see that whole section A redone.
Okay. Or maybe Article 5 redone.
In regards to the vacancies, section 2.
Oh, okay. Well, I think it goes hand in hand with the selection section, which we can do, and then we can adjust the vacancy section too.
Okay.
So Catherine, what do you mean you would like the whole section to be redone? So is
Well,
it?
Just like Ken said, so they can go hand in hand with each other.
Okay, so they would match, so that it
Yeah.
will be consistency between the two areas.
Yes.
Oh, okay. I thought you meant you wanted to just wipe it out and start all over.
Oh, no.
Okay.
Do you want us to add some kind of a qualification section for commissioners?
For qualifications for all commissioners?
Well, maybe specifically for the public sector commissioners and the community sector commissioners.
Yeah.
Well,
Okay.
I know for the public sector commissioners, I definitely want to see something in regards to attendance, but I don't know if that would maybe fall under a different section.
That would go to removal.
So is it possible, I mean, the law has changed a lot lately and people just like plain English better. And so maybe just straightening, tightening up the language to even,
Sure.
So it's more clear. But if you're going to set qualifications, and I think we have a job description for commissioners, don't we, Linda? It should be general for everybody. It should be for the public sector, the target, the community sector, whether
Yeah.
I don't know how we would ever enforce it. If somebody's willing to run for office or run for the board, what are you going to say? Your IQ isn't high enough?
Well, I think the target area commissioners, you're going to be limited, but I do think for the public sector and the community service organizations, community sector organizations, I think you can,
you there?
state that they have a certain amount of experience in one of the following areas. You can do that as a condition of ratification. And that's not unusual for bylaws.
I guess my concern, and this is coming from the public sector,
Sure.
and I'm going to use the mayor as an example. And I think, Amelia, you might have said it earlier. Okay, what if the mayor's appointment is another councilman and not a community person? See, that would be my concern, that then you're appointing a council person to the board because the mayor appointed him versus the mayor appointing someone from the community of Fresno with interests, who wants to see, EOC survive and strive and meet their goals. Okay, the same thing is applied to, and I'm gonna bring it out. Commissioner for the State Community College. We had a commissioner that was a trustee. Should that have been placed?
Jimmy,
Yes.
that is actually expressly provided for in your bylaws under section 2A, where when there's a vacancy, it says that the board shall request that the public officer either take the seat him or herself or put forth another representative. So it's actually in there. Now, if you want that out, that's something we can do, but it contemplates the idea of the public officer being appointed by the city council, for example, or a state senator to serve on your board.
Yeah. That's a problem. And that's just me. Others may not agree with me.
That's why I note in my comments, I said this would trigger mandatory Brown Act compliance. That's a big deal because
It is a big deal. It is.
and when my understanding is when you've had elected officials serving on your board, they have not served in the capacity as a public sector commissioner.
Mm.
So I
Anybody
mean,
else?
I'm here to scribe whatever you guys want me to, but I just want to call it out.
Okay, thank you.
Okay. So with that direction on that section, let me work with Karina and Amelia and I'll see what I can come up with via red line and then circulate it back to you for the whatever special meeting we set up for this committee.
And Ken, I can do the research like the law community action agencies, there was written in law what their tripartisan is supposed to be.
Yeah.
So we'll go back to the original text, that what was the whole purpose of making sure we have public, target, and community sector represented, and go there. We'll start from
Okay.
there.
Thank
And
you.
we'll work with you on that one, since we have all that stuff and we have all the ledge history here, so.
I have a clarifying question. When we're talking about the requirements or, their list of experts for commissioners and for our board to verify, how would verify that information? As opposed to just ratifying, like, when they get appointed, let's say to our board, as with just an appointee letter, would they also submit, backup documentation as to how they're qualified to sit on a board? I want to make sure that I provide our board with what they need in order to verify.
Good question. Karina, the way to do it is you'd have an application and an attestation. They would have to attest under penalty of perjury that their qualifications meet whatever is required by the agency.
Ken, that is exactly what we do for any county appointments, right?
I don't recall that being that. Maybe you would know better than I would.
I know, I was thinking that's what we did for First Five.
Oh, well, you mean when they submitted their application to the county of Fresno? I don't remember seeing, was there an attestation on that form?
Yeah, and then it's information that they meet one of the criteria and qualifications and all the parameters that are stated in the statute. And what was the second part? I know there's a way we can do it. Yeah.
Okay. All right. Yeah, no, we can go back and look at that, but it's a great question, Karina, and I think it's something we can address. So under 2C, we kind of already addressed that, the issue of associated. Under section 4, scroll down just a little bit. The way this, it was a little unclear about removal, but it mentions that the appointing authority can remove at will and nominate at will. So I guess what that means is that they can remove for any reason, because I didn't, that's with an appointing authority. So that would be the public appointments, the public sector commissioners. That's what's in your bylaws. And then what I tried to clarify is under, if there's going to be removal by the EOC board, that the list, that the reasons be enumerated, which you have in your bylaws, such as incapacity, cause, negligence of duties. So you'd asked, I think, about the vacant, about the missing meetings. And it says here, it says the board may remove a commissioner by resolution after 3 absences in a calendar year. Is that something you want to change?
Well, I think, do we want to change it so that it's just after just 3 absences, or do we want to give them a chance to give explanation like we do with the other board commissioners?
That would be fair and consistent. That if they have an opportunity to, you notify them that they've missed 2 absences, and then they have the right to appeal.
Mm-hmm.
So there is some consistency there.
We used to have a way they had to excuse the absence if for some reason you weren't able to attend, as compared to you just missed it for whatever reason.
Well,
So
that was
explain
before, Charles, wasn't that before we went to where you could phone in?
Yeah, you could phone in too.
Well, before, when I first arrived on the board, it was in person.
It was in person. It was
And
in person only. If you couldn't make it, you had an excuse, you were fine. You didn't get docked for missing the meeting.
Right.
So
We can put
The
in.
reason,
Oh, I'm sorry. Go ahead.
sorry, Charles. The reason that they got rid of that, I remember, was that everybody had great excuses, and therefore you could miss 9 out of 10 meetings a year, and what the heck. So they just decided the point is we want people who are participating and actively participating, So we don't want to have to go through why were you missing. The whole
Yes.
purpose was 3 out of 10 meetings. If you've missed that many, that's quite a lot. You know, if you had chemo or you had some major issue, there was the thought of, okay, we want to provide excuses, but we didn't, you know, I remember poor Esther for the longest time was really sick and whatever. And, you know, it just got too complicated with excused, unexcused. The point is you want them participating.
No, you're correct, Amy. We had the problem. We had some that just didn't even show up at all. You know?
But those were not community or elected people. Let's go there. It was a public appointee that probably attended 1 out of 10 meetings.
Mhm.
You know what you
And that person could not be removed because they had been appointed by an assemblyman or the mayor or whoever.
Now, it's something to really give some thought about. I mean, trying to figure something out right now is be a little difficult. I'd rather think about it.
But the rules should apply. I agree with you, Jimmy. If you're supposed to attend, everybody should attend, whether you're
Everybody
community, target, or, you know, from an, you should be present and, you know, the letter
And that
should be.
was why, Amy, if you remember correctly, that was why we went to allowing folks to phone in. Because if you couldn't physically get to the meeting, possibly you could phone in from wherever you were.
And I've done that. I phoned in when I was at a work-related conference out of town. I phoned in.
Me too.
Yeah.
I've done it.
Could I address a couple points on that?
Yep.
The first thing is, under removal, the way this is drafted, it doesn't actually exempt the public commissioners, you know, the public sector commissioners. It just says, before I changed it, a commissioner can be removed by the board. A commissioner can be removed, or any committee from the board, or any committee from any office for the following reasons. It doesn't actually, it doesn't exempt the public ones, number one, which is interesting. And number two, on the phone in stuff, that actually, we're kind of lucky because of the executive order. So not really lucky because we were dealing with COVID, but we're lucky because the executive order allows us to do meetings like this.
Mm-hmm.
But because we're now Brown Act compliant, doing teleconference meetings is a whole new thing. Now, I do think that the rules may change after what we've gone through, but I can't promise you that's the case. So I wouldn't rely on the notion that you'll be able to participate on the phone and be included in quorum and vote. So that's one thing I just wanted to mention. The last thing I wanted to say is that under that excessive absence language, it says the board may remove a commissioner by resolution. So it's not mandatory, it's discretionary. So one thing you could do is you could say the board shall remove a commissioner by resolution after 3 absences in a calendar year, or you could say something like their position is deemed vacant unless they've submitted appeal, which will be discretionary by the board. So,
Which
you
they
know,
have done in the past. They gave a letter as to the reason why they missed 3 meetings.
but the discretionary is more of an appeal as opposed to, you know, allowed absences or approved absences, authorized or unauthorized absences. You would eliminate that altogether. It's a couple things to think about.
Yeah, it used to say shall remove.
Yeah.
That
Also, when we went to where we could call in, we could only participate in the general meeting. When we went into closed session, we had to hang up.
It's interesting.
Yeah.
Sorry to be the bearer of bad news, but not anymore.
Can I have a clarifying question?
Yes, ma'am.
When you're talking about may remove, you know, up to the discretion of the board, is that done in a public setting or in closed session?
Public.
And do they have to vote on it, or is it?
Yes,
and majority vote.
yes.
Just so you know, Karina, we have never removed anybody for absence that I
Okay.
have ever known. We accept every excuse in the book. We do.
Well,
Well-
I'm gonna be honest, I'm gonna say, Amy, and you know this, we only had one instance, and that person should have been removed.
You talking Esther?
Yeah, no, Esther was held, no, Esmeralda,
Oh, I didn't know Esmeralda. Yeah, I
sorry,
wasn't around. Yeah.
no,
Oh, yeah, she never came.
never came to the meetings.
Never.
Once, she
Was that
did
One
come
time to be,
once, I remember.
one.
We were told we couldn't remove her
Yep.
because she was a public sector appointee. And 1 year she didn't attend any meetings.
Mm.
Yeah.
Yeah, we'll take a look at the research on that and see what the statute says regarding removing a public sector employee, but your bylaws do not make that distinction.
I
I do know our bylaws.
I have another place to be at 6:30, so I know
Okay.
it just appears to make it a form. This is an item that we're not going to vote on, right?
No, in
No.
fact, we're gonna have a special meeting. We'll bring it back to you in red line well in advance, and then we'll go through it again and make sure everyone's comfortable with it before you recommend it to the entire board.
Okay, yeah,
And
this was the
so
only
now
item
the,
left item on the agenda before our next scheduled meeting, but yeah, I have to leave right now, so, yeah, I'll just, hopefully we could get something like this before our next meeting and our special meeting. So it'd be helpful.
Okay,
Okay, well, I'll see everyone. Bye.
Thank you.
Bye,
Bye,
Charles.
Charles.
Thank you, Charles.
I don't know if you guys recorded Channel 30, but for Black History Month, they profiled Dick Keys this evening.
Oh, Really?
Oh,
Yeah.
oh, I didn't know that.
Yeah,
I know they've been profiling
Dorothy.
Dorothy Thomas.
Dorothy.
Yeah.
So, yeah, tonight was Dick Keys.
Oh,
So,
Oh,
so
I don't
I
watch.
had it recorded so I could watch it.
Oh, okay. So hopefully I'll catch it again.
Yeah. Well, you can probably catch it on their website. So,
Yeah, I'll do that.
yeah. So anyway, good night, everyone.
All right, thank
good
you.
night, Charles.
Good
Good
night.
night.
good night, Charles.
Just to be clear, so Michelle Tatunjan sent me some really valuable information on this I'd like to review before you see your next draft. And I think that'll help answer some of these things. Thank you, Michelle. Actually, the next sections are not going to be all that important, or at least that shouldn't take much time, but the conflicts of interest rules, you'll have to comply with Head Start rules. But also I've added in all of the various governmental conflicts things that apply to public entities, as you'll see. The one thing is the language that talks about compliance with Head Start regulations is actually always evolving. And so one thing that you might consider doing is having a separate conflict of interest policy that includes all of the Head Start changes that happen from time to time, and then delete the language that starts in compliance with Head Start regulations down to relevant conflicts of interest in that section. Because I think it's a more evolutionary thing, and having in your bylaws probably isn't necessary to make you have to comply with those conflict provisions. On the sentence before that, I say, and Head Start regulations. So something to think about. And then I added a section. Under section 7, it says employment of commissioners. You have a 6-month prohibition for working from the agency once a commissioner leaves. And the more standard, and the one that is in California state statute, is 1 year. And you see that for special districts and for state agencies. I just didn't know if you wanted to modify that. That's where a commissioner is then employed, unless the commissioner falls within the poverty guidelines, and then it's reduced.
I would like that. What about you, Catherine?
I would too. The other thing was what happened this past election period was with our ex-employee that wanted to get on the board, do we have nothing in our bylaws in regards to employees leaving EOC then wanting to get onto the board?
That's pretty common and not prohibited by law so long as they're no longer employed.
Okay.
If you wanted to put a waiting period in there, we could. It's usually the other way around where they're a commissioner and then they want to be employed. That's typically like a conflict of interest issue.
Okay.
But we can put that in there.
I mean, we allowed her to continue. We just didn't know. We were just like, oh, okay.
Well, we looked at the bylaws and it wasn't specified in the bylaws. That's why we allowed it to happen.
Yeah.
One other thing is, this only speaks to employment. It doesn't speak to contracting with the agency. And I would really strongly encourage there be some kind of a gap between a commissioner serving on the commission and then, contracting as a consultant with the agency. Because it really evinces conflicts and, what if they were involved in negotiating it when they were on the board? That's illegal. So
I would like to see that on here.
Yeah.
Absolutely.
Yep, I agree with that.
okay, I'll add that. Okay. And then going down, I added the Brown Act compliance section. So that's in there. And I made this whole notice section compliant with the Brown Act. And going down under section 8, participation by conference telephone, I made it consistent with the Brown Act, which is what I was mentioning to Jimmy before. There's certain mandatory notice requirements after we're done with COVID, unless the law changes. So I just made it consistent with the Brown Act. Under section 9, you could do action without a meeting. That violates the Brown Act.
Sorry to interrupt. Did we agree? Did we get feedback on whether we wanted employees, a waiting period from employees to board members?
Oh,
Did they provide feedback on that?
We just kind of, Ken basically said that he hadn't heard of that before, but we did not. Catherine, did you have anything else to add to that?
You know what? I really couldn't hear what Karina said.
Oh, Karina was asking about whether or not I got sufficient feedback as to whether or not there should be a prohibition on employees to be appointed on the board. Former employees.
Well, I mean, if the rest of the group is okay, I mean, it's.
Oh, I'm going to give you an example right now. That one happened to apply to the community sector, right, Catherine?
Yes.
But when we get right down to it, we have a public official that's a former employee that was appointed. Brian King was appointed by the mayor. He was technically employed by EOC. So that's a little, I think I'm okay the other way around, the employee, the board member. I like that 6 months span before the board member can work for the agency.
Well, I was recommending 1 year on that.
Or 1 year?
Mm-hmm.
Oh, okay.
To be employed or maybe even contract with, because that's more consistent with state law.
Okay, all right.
But
And
I'm sorry, I
no,
interrupted.
I was going to say, I agree. I think you need to put that language in there or contract with, because depending on who the employee is, they have historical knowledge with certain programs, and they could, if we don't have that language in there, they can go after some contracts.
And we did sort of end up in a major, Amy, were you here then? Shaw? We did end up in a major discussion one night behind just that issue. And the person having less than 6 months and was placed in a position.
One thing, just to go back to Catherine's question on that, one there is a prohibition on someone being an employee from going on the board. that's not that under nonprofit rules, that's okay, but under governmental rules, it's a violation of statute. So
Okay.
I can put in some language that would prohibit that. Like if Brian was employed, for example, if he was appointed onto the board, but was also an EOC employee, that would be prohibited.
Okay.
But I'll make sure we add that.
Thank
Karina,
you.
is that good, or you?
We're just wondering about the waiting period. If, you know, it's used in one way, but not in the other way. We just wanted to have that clarification.
Okay.
Glad you brought that back up, Karina.
If I could, I'm going to jump off real quick, but I just want to encourage, I know you guys are talking about redoing the articles of incorporation and the purposes, the section on purposes
Yeah.
needs a lot of work.
It
Ken,
does.
good luck. Okay, thank you.
Thanks, Amy.
Bye.
Bye, Amy.
So the rest of that whole area is really Brown Act stuff. One other, if you could go down to section 5 under Article 9 under officers. I think if you keep going, this needs page numbers.
What article are we on?
Are you on the removal of officers?
Yes, removal of
It's on
officers.
page 29.
Okay, got it.
For some reason, it's not showing up on mine.
One more cream. Right
There
there.
we go. There was something in there that I didn't really like because it says any commissioner can bring forth to the bylaws committee a recommendation for removal of an officer. Do you feel like that gives the commissioners, any one individual commissioners, a lot of power to try to submit a petition to the bylaws?
Yes, yes, and yes.
Yep, yep.
Yep.
Okay, so I think it would have to be something like the board of directors may consider an action to remove an officer. However, prior to any motion being considered by the board, it should be brought to the bylaws committee. Maybe something like that.
Okay.
I just don't like the idea of one member having that kind of authority.
Yep.
Okay, next page under Chief Executive Officer. Amelia, did you have to post a fidelity bond?
Sheila?
Can you hear me?
Was I supposed to?
It's in your bylaws.
Not in my contract.
That is so antiquated. Normally you just have insurance, and you have maybe even a crime insurance is what they call like fraud insurance for the agency. You shouldn't have to post a bond. So I strongly suggest striking that. I know you have E&O policy. So.
What's E&O?
Errors and emissions.
Thank you. Errors and emissions, but it's really like director and officer liability insurance. So it protects your directors and officers for acts that they take that are within the scope of duty as a director and officer in case they're ever sued. And if the CEO commits an act of fraud, they have insurance for that as well. It's usually like a rider or some kind of an endorsement to that policy. I had the committees comply with the Brown Act. You go through the different committees, which is fine. And then just so you know, I also added way at the end some language. You didn't have very good language regarding indemnification of commissioners that I felt complied with state statute. So rather than going in great detail, it'll be there, but it essentially says that if you're a director, officer, and employee of the board, and you're acting within the course and scope of your employment, there's a duty to be indemnified. And those are my changes.
A lot, you put a lot into this, Ken.
Yes, this was really good.
Linda,
Yes.
do you remember one time, and my gosh, there was something about, and I want to say in regards to holding a meeting, I can't remember, but it had to do with the Robert's rules, the orders, and there was a discussion like with Danny saying that, yes, we do. And I don't know if it was for a particular type of meeting. Do you remember?
I don't remember the details. I remember one time we talked about Robert's rules, following the Robert's rules, but I don't know in what context that came up. I know
So
Danny.
that's not in your bylaws. It's common to add those to your bylaws.
And it was, I do remember it now because
Yeah.
he challenged me on something and I said that we don't follow the Robert's rules.
Oh, yes, I remember that now.
And he told me that we did, and I told him that we did not because it wasn't in our bylaws.
And I think it was for just a specific type of meeting too. It wasn't just for general meetings.
It was the special meeting when we were interviewing candidates.
Okay, there we
Am I
go.
correct?
You're right. I didn't want to say it, but yes.
I just want to make sure that that's addressed in these bylaws if it's corrected and that never comes up. And
well, like I told him, we didn't follow Robert's rules, and he tried to tell me that we did. And as you can see, as we're going through these bylaws, we do not.
Okay.
Yes.
You know, there's some argument that it's good to add it, but what most boards do is they don't really strictly adhere to it. They do what's called Robert's Rules of Order Modified, or Modified Robert's Rules, which is sort of more of a casual version of Robert's Rules. It's nice to have it to ensure that, you know, for example, you don't have multiple motions happening, and you know, so it might be something you want to think about. We could potentially add something like that.
Okay.
I'll leave that up to you, Catherine.
That's another discussion then.
I just had to clarify.
I just remember that night. Yes, Jimmy, you're right. And he did challenge Linda, and you know, it was, and Linda stood her ground. She did a great job.
Yeah, he shouldn't have, since I got him one night on speaking out or making a decision. I'm going, you're the chair. You weren't supposed to say anything. So, all right. So as you go to the end of this, your everything, and I notice now we have in front of us everything that you brought up. The articles.
Yes, ma'am.
Attached and everything, and our charter.
I think I just have your articles. I think I gave you a Word version of the articles because I it's easier for me to search it, so that's why I included it that way. I had it typed up.
Yeah.
So Ken, if our articles need, I guess it sounds like they need an overhaul. So if you're going to overhaul the articles, then are you going to have to go back again to bylaws?
Well,
and revise that again, or how's that going to work? Are we putting the cart before the horse?
No. What you're going to get is at the next meeting, you're going to get a brand new set of articles. And then the purposes section in the bylaws are going to be exactly the same, because that's really the way it should be done. Okay. And that way you'll be able to, once you review the bylaws on the purposes section, then you'll have effectively reviewed the articles. There's a lot of things in these articles that are very uncustomary because they're very old. So typically now articles just specify bare bones things like the purposes of the organization, I think the location of the organization, and a few other things. So your articles are going to be a lot shorter and a lot more concise. You're not going to specify who the initial directors are and all that jazz. It's all going to be gone.
Look at the 11th. You could read it more on the one you have typed. And see, and it says this corporation
It was
is,
previously unincorporated.
yep,
Yeah.
and look what the name.
There you go. It's like you've come full circle.
Mm-hmm.
It's funny because it says it was an unincorporated association with the
Mhm.
name Inc. in it, comma Inc.
Mhm.
So they projected themselves as a corporation but never incorporated.
But never incorporated.
Yep.
Can I have one more clarifying question when it comes to the committees?
Yes, ma'am.
In here, we outline how many shall be composed of. Should we change that or update that? Just
Is that not how is that no longer the composition?
no.
If that's no longer the composition, then it all has to be changed.
Yeah.
I can work with you offline, Karina, to get the current composition and make sure we add it in as a red line.
Well, every year we update it, and every year they get, commissioners get appointed to this committees. I don't know if that is always.
So maybe you should put a range. So there should be,
Well, I like that.
well, you know what, Karina? And this is something that I should have. Normally, I would appoint people, well, the chair would appoint people to committees based off of the bylaws. So if it said 5, would have made sure that there were 5 commissioners on the audit committee. Does that make sense? That way you're not changing the bylaws every year. So the finance committee is the chair for 4 other commissioners. So it would have made sure that those numbers, the people appointed to these committees match what the bylaws say.
So am I hearing that we want to keep the same amount?
I'm okay with changing the amount, but what I'm saying is, I think that we shouldn't change the bylaws each year to match what the chair appoints to committees.
Right.
The chair should appoint people to the committee based off of what the bylaws numbers is.
And I think that, and I think I meant that perhaps we shouldn't outline how many, perhaps just, a combination of different tripartite sectors.
It has to be it does, but I'm just saying, I usually have this information, but like I said, I didn't have it. I didn't even think about it, but previous years, the committees matched up to the bylaws, the number of commissioners on each committee.
Okay.
Because it would be a nightmare to change your bylaws every year based off of what the chair appoints to each committee.
Yeah.
So they need to follow this guide.
To follow the bylaws.
Yes.
And just for my own knowledge, how were these numbers? How did that come about?
Pardon me?
How were the different committee sizes came about?
I have no idea. I don't remember. I don't remember, to be honest with you.
Some were 5, some were 4.
And it might have been based off of the importance. I don't know. I don't know. I really don't.
We can, since the number seems to fluctuate, I think maybe as opposed to maybe even a range.
And that's what I was thinking, a range.
Well, you could say up to 5 commissioners or up to 6 commissioners. The only risk
Ken, I would say a range because you got to think about a quorum.
Oh, I see.
Because
3
if
to
you
5.
say up to, you might just get 1.
That's true. That's true. Well, it's based upon appointment, but you're right. I mean, we could do that. My only concern, just as counsel, is that there not be 12.
No, right. My thing is, it has to be you have to have 1 from each section. So the minimum will have to be 3.
Mhm.
and then you can close whatever the maximum is.
Okay.
Or do we even have to have a number and just say, as long as it's a comprised of a quorum with the tripartisan component in it?
You
Can't,
can do that. So as
But
long
what
as,
is the quorum?
Yeah.
well, well, but see, the quorum isn't so much as prescribed by the bylaws. The quorum is if you have the bylaws that say it allows up to 5 and you have 5 appointments, then the quorum is 3. If the
Right.
bylaws say you have up to 5, but only 4 have been appointed, then your quorum is still 3. So it doesn't really speak to the quorum for the committee itself. It's just the number of commissioners.
And then the other thing that I wanted to clarify, I believe that the executive committee is missing. So we have the elected officers as well as the chair of the audit, bylaws, program and planning, HR, and pension. We didn't mention finance in here. So the finance chair is not technically included in the executive committee.
Karina, send me, if you would, in the red line Word version I sent you, send me your notes and I can adjust that based upon what you just said and also the comments by the bylaw committee members.
Okay. And then my very last question, Ken, I promise, is
Sure.
You mentioned each standing committee shall comply with the Brown Act. These are the committees that we have outlined here in our bylaws. What about our advisory board meetings? Do they have to also follow Brown Act?
I think I rendered an opinion on that. I think they do if they're standing, but if they're not standing, meaning like they're ad hoc committees, then they do not. But since those, I don't think those advisory committees are even mentioned in here, I don't think I referenced it.
And can committee meetings be online
Yes.
even after the pandemic?
No, if they're standing committee meetings, oh, you mean, can they be entirely electronic, like Zoom? Not after, well, unless the law changes, they cannot be. They have to be in person. Again, I do think that that's going to change. I really do.
Okay.
But I don't know for sure.
I think it's going to change also. It just even like in healthcare, it's going to change the way we deliver healthcare. Everything is not face to face.
Yeah.
Okay. Do we have any more questions for Ken?
I know this was shot down last year. I just want to bring it up just in case, see if we're open to it. Consolidating committees?
You mean like consolidating, meaning like making audit and finance one committee? Is that what you're
Yes.
talking about?
Yes.
I'm not opposed. Oh, I'm sorry, Catherine. I'm sorry. Go ahead.
So that would mean you would combine the 4 on finance and the 5 on audit and make it 1, so we'd have 9?
Well, even thinking about pension,
Okay.
maybe, because it's the same members. So if we just combine maybe finance, or we can put pension with HR, we can do finance with audit. I was just seeing if you're open to that so we can come with a recommendation.
Oh, I'm open.
I'm not opposed.
Okay.
I'm not opposed.
So what was the recommendation?
Consolidate some of this committees.
Do you guys want to kind of work on that offline and then?
Yes.
Okay. All right. That's great.
Okay. Any Anything else? Any other questions or comments?
Not,
Okay. Well, then I think we have to make a motion, and I guess the motion, is the motion going to?
we make a motion without a quorum.
The motion would be to continue the item to a special meeting that staff will schedule before the March board meeting.
Okay.
And hopefully sooner than later.
Okay. So we need a motion to come back for a special meeting in order to give Ken time to make his corrections so that we can approve the new bylaws that will be presented in the March board meeting.
So move.
Second.
Okay, any public comments? With that being said, let's have a roll call.
Catherine Robles,
Yes.
Charles left, Jamie Rogers,
Yes.
and Linda Hay.
Yes.
Thank you.
Now we move on to other business, number 7. Next meeting is scheduled for, well, no, we'll have a special meeting. So, but the next official or calendar meeting will be Wednesday, May 19th.
I did want to bring up there's a commissioner that's another commissioner is supposed to be part of this bylaws committee that it conflicts with the board.
Commissioner Nichols had requested that this committee be moved to, I think, the second Tuesday.
I talked to her, it was second Wednesday.
I mean, Wednesday.
It's third Wednesday, I think it's a bit of conflict. Given that the bylaws only meet on a quarterly basis, we really only have to adjust 2 other meetings. And so just think I wanted to bring this up.
Okay.
So instead of May 19th, it would be May 12th. So essentially scooting it up a bit.
So Karina, are you saying we will just adjust 2 meetings to have them the day before the regular scheduled meeting?
Yes.
And did you see if that conflicts with any other scheduled meetings?
I checked in with Commissioner Nichols and her Fresno Unified board meetings. I also compared it with the rest of the committees. So it should be fine to be on the second Wednesday of on a quarterly basis.
No, the question I'm asking you is, are there any EOC committee meetings on those days, those 2 days that we want to switch to? Because other commissioners might be on those committees and it might be a conflict for them.
Yeah, I checked those dates as well.
Those days are good?
Mm-hmm.
Okay.
So clarification, because some feedback. We're staying on a Wednesday, but it will be a different Wednesday of the month, right?
Yes.
Okay.
I just thought you said there was just 2 meetings that was a conflict, so we would have them on a Tuesday. No?
No, it's second Wednesday of the month on a quarterly basis. So we're just putting it up by 1 week. So instead of May 19th, it would be, for example, May 12th.
So it'll stay on Wednesday, May 12th.
But
Gotcha.
we're just making it the second Wednesday instead of the third Wednesday.
Instead of the
Correct.
third.
On a quarterly basis, how this committee meets.
So do we want to just make a motion to move our bylaws meetings from the third Wednesday to the, I mean, is it the third or second Wednesday?
It's
Currently
the
the third.
second.
The second Wednesday to the second Tuesday.
Could I suggest that you just do it by consensus because it's not actually on the agenda?
Oh, okay.
And it's not a
okay with
Tuesday.
it.
It's not a Tuesday. We're moving it from the third Wednesday to the second Wednesday of the month.
Second Wednesday?
Of the
Okay.
quarter.
Okay.
Yeah. And I can update the schedule, calendar invites, and everything else. So
Yeah.
decision. So you won't have to think about it.
Okay. Everyone's in agreement with the second Wednesday?
Yes, we are.
Yes.
Okay. All right.
Then
Well, then,
Catherine,
yes.
Karina, rather, will you be sending out a doodle as to possible dates for the special meeting?
Yes, I'll have you here. Maybe I can. So we want a special board meeting, a special bylaws committee meeting before our March meeting. So would the second week of March work?
I still think you should send out a doodle since you have some members that are not here tonight.
And right now, it's just the three of us.
Just when you do that doodle, March 1st, I'm not available.
Yeah, I think she was gonna do it for the next week.
Okay.
I think if we give Ken about 2 weeks to
So
incorporate.
Monday, the 8th is out. I think that's, no, that's the old HR meeting. Okay. I gotta do some deleting.
So, Ken, do I need to ask for public comments again?
Yes, ma'am.
Okay, so number 8, we're going to move to public comments before we adjourn. With none being said, can I get a motion to adjourn?
So move.
So move.
All
Can
right,
we
Lisa
stop the
Ryan.
Have we stopped the recording because I want to share something real quickly? Okay. With my year,